Morning, ma'am.
Good morning. How are you?
Good, ma'am. How are you?
All good, thank you. Yeah, absolutely, Sudhakar. And right from the Supreme Court, which is what has now been keeping the WhatsApp factory very busy. I think there's just too much happening on that space now.
Yeah, that
But I
is true.
say
Very
that
recently, there is a judgment from the Supreme Court talking about the company secretary role and responsibility, especially what has happened with the SEBI SAT order actually on
But
the buyback.
actually, but if you refer to Regulation 19,
Yeah,
which refers to obligations of the company, a
correct.
company secretary's obligation cannot go beyond the obligation of the company. While 19.3 does refer to the obligation of the company secretary, it has to be read in conjunction with 19.1, which nowhere refers to the figures. And if you refer to the schedule, there is a very clear reference to a certificate to be given by an auditor. So the responsibility and the auditor's certificate will be given at the stage when the board approves the limits. So it is not something where it is coming later. Similarly, the due diligence certificate, while one can argue that the due diligence certificate is given to SEBI and not otherwise. Of course, going forward, that provision also changes where you don't require application to be filed with the scheme to be filed with the SEBI if it is a purchase through the tender route. But having said that, the merchant banker's responsibility is primary, and the company secretary falls low down on that particular hierarchy and waterfall. So therefore, 19.3 has come out of the blue, but in my opinion, it will not get sustained eventually.
But only one thing with out of all these things, if you see the regulator mindset. The regulator mindset, he says anything goes wrong, it is the company secretary, the first person who will be responsible. In fact, take a clue from that. The company secretaries have to be aware of that. By that, don't think and don't be in a slumber. Okay, that nothing is going to happen. So
True.
one should be very careful about this thing. Having
Yeah.
said that, I think Bala, now you can start the program. It is almost 11:03.
Yeah.
Already participants are joined.
Good morning to all of you. I have a great pleasure in welcoming you all for this session of Secretarial Standard 2 to understand the nitty-gritties in the changing circumstances. And today's topic is very much interesting because we all lived prior to 2020 physical meeting. But thereafter, especially the COVID situation has come, the things have changed drastically. With the result, people started working from home. People are not able to travel. People are not able to communicate each other. But at the same time, the compliance which is required remained. So with the result, there have been a lot of changes have taken place. So the virtual meetings, board of directors or general meeting or other extraordinary general meeting, everything has been brought out. If you all will recollect, in the year 20, I think April onwards, there are almost half a dozen circular has been issued between April to September on this issue, giving a various clarifications. Because even today, when we are talking about the virtual meeting, etc., there are a lot of if and buts. What is the role of the company secretary? When you say the virtual meeting, is it the absolute virtual meeting or it is a hybrid virtual meeting? You know what I'm saying? Hybrid virtual meeting means some of the people are actually physically present, other people actually join. It's a mixed. So in such a case, there are various questions. In case of the virtual meeting, what is the venue of the meeting? Whether proxy is actually permitted. Now, again, the internet, it goes out of circulations. Suppose 5 minutes internet goes, it resumes, or half an hour it goes, it resumes. Chairman is not able to get connected. Then what happened to the meeting? Whether adjournment will apply, or we'll elect the other chairman, or we will continue. All these questions actually comes into the mind. There are various things which are there as we go along, we get evaluated. And again, there are various clarifications. Our institute has been doing excellent job. In fact, the institute has actually brought out the Secretarial Standard 2 on general meeting, which has been made mandatory in the 2013 Act. Thereafter, there has been a guidance note has been issued by our institute. In the changing circumstances, they have modified SS2. They have given the guidance note. The latest guidance note has also come. And very recently, in the recent past, rather, not very recently, in the recent past, I could say, lot of ROCs are actually scrutinizing it on the online, the various document which is submitted, financial statement submitted, board report submitted, etc., and other things and all. And they are actually taking the action wherever the non-compliance is there. There have been a lot of cases, non-adherence of the Secretarial Standard 1, non-adherence of Secretarial Standard 2, etc., where the company secretary, as Sudhakar has put it very clearly, it is nowadays regulator or recognizing the company secretary is basically responsible ensuring the compliances under the Companies Act. And in case of the listed companies under the SEBI regulations, whatever regulations actually specifying, to that extent, the company secretary is actually getting more responsibilities, more responsible for the compliances that is actually happening. And not only that, very recently, I also seen a couple of cases where the chief financial officer, wherever he is involved, especially you are aware that his active role is there in the CSR matters. He has to give what is a CSR budget versus actual, again, transferring the unspent money. All these cases are there. There have been cases also. So they are also becoming very vigilant nowadays. So now what is happening is either company secretary in employment or the company secretary in professional. We have a lot of things to learn. We have a lot of things to understand the nitty-gritties. What is our role? What is required to be done? What is the do's and what is the don'ts? What happens in certain circumstances? All these things are very much utmost importance actually. It is more so for the people who are actually in the active employment as well as the practice who are going to certify the various issues. Now again, in the past, when we used to have the physical meetings, in case of the general meetings, I'm talking about the annual general meetings, if any resolution which are passed only the special business, then only the required form is required to be filed. Now in the virtual meeting, even the ordinary resolution which is passed, that is also required to be complied with. Of course, there are certain relaxation has been actually given in terms of the filing time, etc., and other things about. So there are so many things which are there in the learning process. And today we have two eminent people, Mr. Sudhakar, who has been there. You have been witnessing him for the last 4 or 5 seminars. You are all aware very much. And he's a well-experienced person. He's a versatile person who has been delivering the lecture across the country. He's actively involved. He is also a secretarial board member. So I don't have to elaborate much. Savithri Parekh, I know her for the last 20-25 years. My association is there, but in the recent past, we have not met recently. But she has been also working along with Sudhakar in the Reliance. I will be taking a pleasure and asking Mr. Sudhakar to introduce the Savithri Parekh. And what we will do is we will take the initial presentation presented by Kanchan Sharma, who is our partner from Hyderabad. And she will take about half an hour, 45 minutes or so to explain the Secretarial Standard. Thereafter, I would request Savithri Parekh, because with her extensive knowledge, with her physical, practical experience in the virtual conducting of the meeting, and she's also incidentally board members in some of the Reliance group of companies. So she will be able to definitely enlighten us with her practical experience, if and buts, do and don'ts, which will be of a great help to all of us, and it will be a great learning going to be like that. Over to Mr. Sudhakar, please.
Yeah, thanks very much, Bala, and good morning, all the participants. But before introducing Savithri, further to whatever Bala said, I would like to add further is that, in fact, when 2014, when this Companies Act 2013 was legislated, I used to call this act the most draconian act out of all the acts, like old FERA 1974. Because this act, the kind of stringent penal provisions what are there, and I used to also say the amount of disclosures what the companies have to do with the ROC. A time will certainly come that ROC is going to do the data mining. That point of time, we will be having very tough time. It has now, the time has come, it seems to be, because the regulator also recognized the importance of the data mining, how it is to be done. It is manually impossible. It is now, so they are using this, all the technical tools, which will help them and enable them to find out the non-compliances. As before before all the participants enter, we were discussing about the regulatory activism, what is happening. wherein all the company secretaries, most of the time the company secretaries are being taken to task. So with this, the clue what we have to take it is that we can't be anymore in the slumber, and we have to be resilient enough, and we have to become agile, and we have to also ensure that any kind of non-compliances are going to be viewed seriously, and we will be the first level of defense who will be caught and maybe penalized also. And at the same point of time, when the secretarial standards were introduced in the 1st July 2015, that point of time also, I used to say that if anybody can save company, I mean, insulate at least about the responsibilities of the Companies Act's rigor of the KMPs or the independent directors in general, and in particular all the directors, the secretarial standards are going to insulate them, because the amount of efforts what institute has taken up while formulating these standards and before getting the same approved by the Ministry of Corporate Affairs. But there was a resentment among the fraternity that when already the so many compliances are there, and further over and above the Companies Act, some more compliances have been imposed upon the professionals. But lot of dust have settled down now. Even the regulator is taking not only the Companies Act provisions, but also the secretarial standards very seriously. Any kind of non-compliances of secretarial standards also viewed as a non-compliance under the Act, which is so definitely. But the penalization has already been started. So my submission every time I used to say that don't take secretarial standards lightly, whether they are mandatory or non-mandatory. They are definitely going to help you as a key managerial person to set up the compliance culture in the organization. And also kindly go through the guidance notes. Why we say this thing is the amount of efforts what the SSB members put in before bringing these publications released by the ICSI. We know as members of the SSB how many nights, especially when Savithri is there, I have become a bit nostalgic. We used to work till early hours, and again up to 4 o'clock, 4:30 we used to work, and again 9 o'clock we are on the table at the ICSI council room for further discussions. So with this, I will give a pause here, and before that, I will introduce Savithri. Ms. Savithri Parekh has around 30 years of experience and is currently a company secretary and compliance officer of Reliance Industries Limited. She has worked in a variety of sectors, including manufacturing, outsourcing services, private equity, media, pharmaceuticals, textile, and chemicals. Savithri is a specialist editor of Ramaya Guide to Companies Act 2015 edition and general editor MC Bhandare Guide to Company Law Procedures 2015 and 2018 editions published by LexisNexis, and a book on listing regulations. She has also been a guest faculty at IIM Calcutta for over 10 years, up to 2006, and she is a regular speaker at the programs of ICSI, ICAI, Chambers of Commerce, etc. She is the chairperson of the governance committee of the Bombay Chamber of Commerce and Industry. As far as the honors and awards are concerned, she is a recipient of Chevening Scholarship from Young Indian Lawyers, which is a full funded by the Foreign Commonwealth Office, UK, and gained exposure to European law. Interned with Richards Butler LLP, a law firm in UK, now known as Reid Smith, and gained hands-on experience in handling notifications under the UK Competition Act 1998. This is the formal biodata of Savithri Parekh. Now, as far as I am concerned, she is a very fine and iconic professional with an elephantine memory, remembering not only sections but also subsections, not only the rules but also the sub-rules. A dear family friend, and I had privileged sharing the dais on number of occasions, and also worked together at SSB for 4 years, and of course at Reliance too. Hearty welcome, Savithri. Looking forward for a great session with you and lots of interactions. Thanks very much. And Kanchan, you may take over now, make your presentation.
Thank you very much, Sudhakar, for the kind words. Thank you. And thank you, Mr. Bala, too. Over to you, Kanchan.
You're welcome.
So, very good morning, all my dear panelists and the delegates who have registered for this webinar. So let me start with our presentation for today on Secretarial Standard 2, SS2 on general meetings. So to begin with, we can first understand the applicability of SS2. Secretarial Standard 2 is applicable to general meetings, AGM or EGM of all companies, including private limited companies and small companies, except one-person company and the companies registered under Section 8 of Companies Act 2013. So it is also applicable mutatis mutandis to the meetings of debenture holders, to the meeting of members or a class of them, or debenture holders or creditors convened under the direction of Company Law Board, CLB, or National Company Law Tribunal, NCLT. And it is also applicable to the meetings of creditors. So here we also need to understand that as per the amendment to the SS2, Section 8 companies, they need to comply with the applicable provisions of the Act relating to the general meetings. So starting with the notice. So let us first understand what exactly does SS2 talk about when it comes to notice. Para 1.1 of SS2 talks about who has the authority to issue the notice. Under the authority of the board only, the notice can be issued. And when we say it is being issued, then we also need to understand who should the notice be sent to. So a notice in writing shall be sent to every member, director, auditor, trustees, to the debenture holders. So in the COVID era, it becomes all the more important for us to understand the mode of dispatch of notice, which has taken certain changes. So para 1.2.2 talks about the mode of service of dispatch of notice, which can be done by hand, by post, by courier, or by electronic means. So SS2 contemplates the dispatch of notice by ordinary post. Rule 18 of the meeting rules explains the transmission of the notice electronically. So there is a lot of significance that we need to understand here for the concept of clear days while issuing notice. 21 clear days are needed, which excludes both the date of issue of the notice and the date of the meeting. So it would mean we are supposed to dispatch the notice at least 23 days prior to the conduct of the meeting. And if it is in physical mode, then we need to take into account another 2 days for the transmission, making it a total of 25 days before the conduct of the meeting. Notice sent through physical mode. Such record of receipt needs to be maintained by the company when it is sent in the physical mode. So if it is sent electronically via email, then we need to retain the receipt or the copy of the mail for posterity. So there's no specific form in which the notice needs to be made, subject to the conditions that the notice states the date, time, and the venue where the meeting is going to be held. So it is also important to understand here that irregular notice, if it is dispatched, then it invalidates the meeting itself. So what should be the contents of the notice? Primarily, it should contain the nature of the meeting along with the serial number, which is mandatory to be mentioned. Date, time, and venue of the meeting shall also be mentioned. And the general meeting should commence within the business hours, ideally from 9 a.m. to 6 p.m. So let's say a company wants to hold their general meeting starting at 5:59 p.m. also, they can still do that, provided it is there before 6 p.m. time. So the commencement of the general meeting shall be within the business hours. So there is a very pertinent question here that we shall understand. Can we shift the venue post issue of the notice? We cannot do so without informing the shareholders of the change in venue and the need for such change, as it was held in the case where Sikkim Bank Limited versus RS Chaudhary, it was held that without informing the shareholders for such change and the need or the circumstances which required such change, you cannot change the venue. So agenda for meeting. So agenda is actually defined as the list of the meeting activities in order in which they are to be taken up. An agenda is to be issued 7 days prior to the date of the meeting. So previous law, it had provided that there was no fatality if agenda was not sent with the notice, but now it is mandatory provision as per SS1 for the agenda also to be sent along with the notice. So drafting an agenda is actually an art so that it is not too verbose and superfluous. It is very simple yet understandable. And it needs to convey exactly what as company secretaries are we trying to convey. So let us now understand the need for quorum. So as we all know that the quorum is 1/3 of the board, but now we are seeing that there is evolution on this front in the e-voting arena. As per NSE Prime, there is a new direction that is beckoning, which provides for 50% of quorum to be there. So I would like to understand from esteemed panelists on their view of this requirement.
The NSE Prime is always, actually, they suggested certain corporate governance measure on the higher pedestal. So one of that thing is that they were actually expecting the quorum of 50% to be for the meetings, which is maybe possible, may not be possible. That is a different thing. But this is not mandatory for the companies as such.
This is only the suggestion which has come. It is not made as a law. It is not mandatory as an date.
Right.
Yeah.
So absolutely, I fully agree with the views. And actually, NSE Prime is more of a voluntary thing where a company registers itself in the prime category. It's very similar to what is currently there in the London Stock Exchange on the main board. So this is considered as better governance. Now, in the context of SS2 and general meetings, in case any of the directors is not present and is not attending, it is expected that the chairman would mention about it. And in any case, under 177, there's a requirement that the audit committee chairman shall attend the meeting. Even the other chairman of the committees, that is NRC as well as the SRC, are also supposed to be attending the meeting. And if they are not able to attend, they can someone else can be nominated to attend the meeting. But with respect to audit committee, there appears to be a bit of a gap in the sense that it says the chairman shall attend, where actually what is expected is that the chairman or any other member of the audit committee, possibly that is the intention, but the statute currently says chairman of the audit committee shall attend. But coming back to Prime, this is a recommendatory one because registration for Prime is itself voluntary. And if you're then saying that you are a company belonging to the Prime category, you are accepting a higher level of governance, which is the reason they provided for 50%. But in the context of general meetings, it's actually 100%, which is expected. Otherwise, the chairman is supposed to be mentioning it.
So moving ahead for understanding the resolutions to be passed at the general meetings. So whether the drafts of resolutions for items of ordinary business be incorporated in notice given the facility of e-voting. So Secretarial Standard does not provide for this as we understand it from para 1.2.5. However, the minutes, they must mention the approval of such resolution. Having said that, all items of special business, they must specify the draft of the resolution to be adopted. we also need to annex the explanatory statement under section 102 subsection 2 to also accompany the notice for such special business which is mandatory. Now the directors and the KMPs, they must disclose their interests, whether financial or otherwise, and all the material facts must be provided as on the date of notice itself. So can a general meeting convened be postponed or cancelled? Secretarial Standard states that a meeting convened upon due notice be postponed or cancelled. If unavoidable, it can be postponed. So in British law, this is pertinent to understand the ruling of this case law because of the changes that have been made in the COVID era. So in British law, in Smith versus Parenga Mines case, as far back as in 1908, it was laid down that it can be postponed only if it is authorized by the Articles of Association of the company. So as on today, how do we understand the jurisprudence of this in India in the COVID era? So application of the theory of impossibility of performance in the COVID era takes precedence because we were not able to send out the notice, let alone conduct a meeting. So law cannot compel us to do the impossible. So we could have used this doctrine for our advantage at that time. However, we must exercise restraint over excessive application of this doctrine. So Supreme Court in Chandrakant Khere versus Shantaram in 4 SCC 57 concurred with this Parenga judgment, saying that the Articles of Association can allow for such postponement. So here I would just like to understand the views from our panelists if they have something to add from their experience during the COVID era.
If I'm not wrong, in the Secretarial Standard 2, it said that once you convene a general meeting, it cannot be postponed or cancelled unless until some force majeure reasons are there for that. Under the force majeure reasons, in case you are postponing it or cancelling, again, the issue of notice and other things you have to comply with. These are very detailed manner. These have been addressed. The issues have been addressed in the SS2 itself. Okay.
So presence of quorum at general meeting. Para 3.1 of SS2 states the quorum to be present through the meeting. So however, section 103 of Companies Act, it has no such specific requirement of quorum to be present throughout the meeting. In today's time, in the wake of remote e-voting, where all the companies have moved towards e-voting itself, we see that the sanctity of quorum is then lost. People are there just to join the meetings and then they are not present throughout the meeting. So any comments from the esteemed panelists on this?
See, it is the response. In fact, earlier also I used to say this thing when I made presentations on the virtual meetings. It is the responsibility of the company secretary that for every resolution, whenever you are taking the decision or passing the resolution, company secretary's responsibility is to ensure that sufficient quorum is there. So that in case of suppose this webinar is going, we know that how many people are attending this particular meeting. So company secretary must be aware of what is the quorum for his company depending upon the number of shareholders. And it is his responsibility to ensure that sufficient quorum is present. Otherwise, the decisions will be challenged tomorrow.
Absolutely. I fully understand and I second the views of Sudhakar. At the same time, Kanchan, the point that you have raised is a very valid point. In the context of e-voting, the relevance of quorum needs to be once again reviewed. Let's assume a company has 2,000 shareholders and 1,500 of them have already voted in e-voting, but at the meeting, only about 20 of them are present. In which case, would you say that the meeting is required to be adjourned for want of quorum? I would say that currently, given the statute the way it is, that's exactly what would happen. Now, taking the same discussion a little further, let's assume at the meeting you have 40 members at the start of the meeting, but after 10 minutes, the members at the time when the items are being read out, these members uh, have exited from the meeting. And let's assume these members had already voted through e-voting, in which case the votes have been cast through e-voting, but these members are not present at the meeting. Now, technically, if you go by secretarial standards, your quorum has to be there throughout the meeting, and therefore the meeting is not proper. But at the same time, when you have e-voting, these persons have voted. So there is a bit of a dichotomy which needs to be ironed out. But let us look at the law the way it is today. You would say that if you don't have throughout the meeting is not valid there. So it actually needs to be reconvened. So in case of e-voting, there is this challenge, and we will need to address this issue as we go along.
Yeah, as you rightly said, Savithri, that though you have rightly mentioned that e-voting has already taken place, but e-voting is not replacing the general meeting because the meeting is mandatory.
Absolutely.
Where the meeting is mandatory, the quorum is also mandatory. Though that act as such has not mentioned quorum is required, though it is not clear terms, it is mentioned that quorum is required throughout the meeting, but that is the spirit of law. That's why in essence, when it was formulated, it was clearly mentioned that the quorum is required throughout the meeting. So the company secretaries should understand that they have to ensure the quorum is present throughout the meeting. Otherwise, despite the fact that resolution is passed at the e-voting, but you cannot take it as the resolution is passed.
Yeah, in case of physical meeting, that's exactly the way it is. And for that matter, until the lawmakers do consider this particular point, now that they have permitted meeting through VC, as I said, this is the law and this is the way it will be interpreted. However, there is a room for review because with hybrid meetings or with VC meeting, this particular point is going to get discussed in future. And probably Kanchan has already triggered the discussion today, I would say.
Anyway, what I will do is I will what's called as NOK, escalate this issue to the SSB Secretariat and whoever are the members going to be for this financial year, that point of time, as and when they are taking up for a revision, they will consider this point. I will do that.
Absolutely. Yeah.
Thank you.
Okay. So moving ahead, para 4.1, it requires the presence of auditors as much as secretarial auditor to be there at the general meeting, or at least their representative. If it's a firm, then their representative to be present at the general meeting. Section 146 of the Companies Act also calls for the attendance of the auditors in the general meeting.
Kanchan, I got a question here. When you say auditor is required to be there, what happens is many of today's youngsters, the company secretary, they think giving the notice for the annual general meeting is required for the auditor. In case of the extraordinary general meeting, they think it is not required. So auditors are not aware there is a meeting is there. So how can they be present when they are not aware there is a meeting is there? When the notice itself is not served to them.
So actually notice is required to be sent to the auditors.
Yeah, I agree with you. Savithri, yeah. I 100% in agreement with you. Notice is to be given for all the general meeting.
Absolutely.
But unfortunately, what is happening is, I've been actually hearing, witnessing from the today's youngsters, no, only annual general meeting is required, EGM it is not required. That sort of a thing is there, and with the result, the things are not happening. So in that situation, I just raised this question because I've been speaking to many of the youngsters. This is what the understanding they think without going through the law.
Right.
Anyway, in fact, there have been actually cases by the ROC also not giving the notice to the statutory auditors for the general meeting. They have actually penalized. There are cases out there. Yeah. Go ahead, Kanchan.
So chairman's appointment to the meeting. So para 5.1, the chairman to be taking the chairman of the board to take chair of the meeting. And if he is not present within 15 minutes of the commencement of the meeting, then the directors are to appoint the chair, failing which the members are to elect one amongst themselves as the chair. So I'd like to understand a little more from our panelists on this, if there have been instances on this particular standard. What are their views?
Savithri, you'll take this?
Sure. Sudhakar and I are actually going to have the same point on this question. In fact, while the Secretarial Standard very clearly says that if the chairman is not present or is not willing to act, or any other director is not willing to act, only then will one of the members be appointed as the chairperson. I would urge each one of you to please go through your own articles also, because the Secretarial Standards will have to be read in conjunction with the articles. And if the articles provide for one of the members to be appointed as the chairperson, you have to ensure that the member is appointed as the chairperson. Now, if the chairperson is not present, and if within 15 minutes the directors, one of the it says if not present within 15 minutes, directors to appoint the chair. As I said, it is not directors to appoint the chair. It will be the members to appoint the chair if the articles so provide. If the articles are silent, then in that case, go by what 5.1 says. Right. Sudhakar.
Yeah, I fully agree with you, Savithri.
Yeah.
So para 5.2 talks about the chairman to explain the objective and the implications of resolutions. So in the wake of e-voting, then the essence of this also seems to have been lost.
So I would just like to step in here, Kanchan. Actually, explain the objective and implications. It was originally thought of to be relevant to physical meetings, because all companies were required to have physical meetings, and e-voting would have got closed the previous day at 5 o'clock. So at the physical meeting, explaining this meant that only persons attending the meeting who have not already voted would get to understand the objective and implication. In fact, SEBI wanted the e-voting time period to be extended right up to midnight of the day of the AGM, because they said unless and until shareholders are clear as to why a particular resolution is put to vote, how do they vote? However, Companies Act and Rule 20 would definitely prevail, because that is the mother legislation under which these provisions are covered. So there was a lot of discussion on this, and post which SEBI then decided not to implement something along these lines. Now, once the voting is already done through e-voting in particular, then getting the objective and implication may appear to have little meaning. However, the intention with which this has been drafted in 5.2 of SS, I would very much laud it. And I would say that, one, this is very relevant to physical meetings where there is no e-voting. Two, even where there is no e-voting, there is clearly an obligation which has been cast to explain the objective and implication of the resolution. Now, when you explain the implication, you are holding the board once again responsible for what has been stated. Hence, it is a good move, is the way I would put it. It is from a governance perspective, it is a good move.
Just to add further to that is why people have not e-voted, why they are attending the meeting, whether it is in physical or virtual mode, is to understand that they want to interact with the board before they are casting their vote. So that's why this provision has been brought in, that the chairman has to explain the objective and implications of the resolution, so that the shareholder will be able to understand that and appreciate it before he casts his vote. So even in virtual mode also, the essence is not lost according to me. It is very much there as it is.
Yeah.
Okay, sir. So coming to the provisions of e-voting. Para 7.2.1 talks about e-voting being a requirement for listed companies where there are shareholders more than 1,000 in number. So there is a limitation of e-voting in case of removal of auditor or a director, including the independent director, as the notice under section 169, it shall be sent to the members and the director 14 days prior to such meeting. But by then, in the e-voting form of conduct of the meeting, the e-voting forms would also have been gone. So any such removal of auditor or a director, it shall require them, to be given a reasonable opportunity of being heard. So what then should they be doing? So they can actually resort to giving a written submission of their case to the company, which can then be attached to the notice, or on the day of the meeting, they have the right to explain themselves on the floor of the meeting. So like ma'am had actually mentioned just a moment ago, Kotak committee recommendations on e-voting, here it is noteworthy to mention, which says that e-voting shall end on the midnight of the meeting.
Some cross-talking is happening. Can you put the mic on mute, please?
I think Mr. Praveen Garg is the person actually who has to mute his mic.
Yeah.
The rest all are closed. Only Praveen Garg is his mic is open.
But Praveen, can we mute your mic?
Okay,
So,
go ahead, Kanchan.
Yes, sir. And again, the clear procedure, the entire procedure for e-voting needs to be explained in the notice as per the provisions of para 8.5.3 of SS2. Voting on resolutions and scrutinizer's role. So para 9.3 states each resolution to be put to vote separately. Even if there is multiple directors appointment, then each of such appointment also shall be made by separate resolutions which need to be put to vote separately. As you know, section 162 subsection 1 and subsection 2, they are both contradictory to each other. Any views from our panelists on this provision for voting on the resolutions in the e-voting?
What exactly I couldn't understand, Kanchan. Please
so
explain.
I was just trying to understand, sir, if you have any kind of views with regards to this particular provision, where each of the resolutions, even if there are, let's say multiple directors which are being appointed, which can be clubbed under one particular resolution, but the SS para 9.3, it states that everything should be put to vote separately. So just trying to understand your views on this.
No, you cannot have one resolution for appointment of all the directors, that you have to have separate resolutions. Under one resolution means you have to say A, B, C, D, E, you can do it. But you cannot say that A, B, C, D, E, F directors are B and he is hereby appointed. Under the act itself, you have to have separate resolutions for appointment of directors. So you cannot club all of them together into one resolution itself.
All right, sir. So para 9.5, it states the report of the scrutinizer to be submitted within 7 days of last date of poll to the chairman. However, LODR provides for submission of such scrutinizer's report within 2 working days of the meeting.
That's correct, because in case of listed companies, they would not want this information to be kept back for 7 days. So if you're a listed company, you have to give it within 2 working days. If you are not a listed company, you do have 7 days time period.
Absolutely right, Savithri, because we cannot discuss which is holding good, because these are two independent regulations.
Absolutely.
Because all the companies are registered and incorporated on the company side, they are bound to comply whatever is saying on the company side. However, it is the choice of the company who has gone to the listing. You have signed a separate listing agreement with the Securities Stock Exchange Board of India. So in such a case, whatever contract is signed, you will have to prevail. So out of 7 days, 2 days. In case of the listed company, it is 2 days. Other companies says it can be 7 days.
In fact, earlier this was 48 hours.
Yeah.
That's subsequently it has been changed to 2 working days. Otherwise, what used to happen was if the meeting of the company was on, say, Friday, the company secretary has to struggle on Saturday, Sunday, and he has to upload that whatever the results are there.
Correct.
Earlier,
You
it
are
was
right.
48 hours.
Yeah, that is right. That was changed to 2 working days later.
That's
yeah.
Just one more. 162.1 and 2, Kanchan.
Yes,
162.1 and 2, basically, as Sudhakar rightly said, that you have to move the resolution for appointment of a director as a separate resolution. You cannot have 2 directors being appointed under one resolution. Now, there is, of course, a provision where you can move a resolution saying that you propose to move one single resolution for appointment of X number of directors. But mind you, that resolution needs to be passed with 100% votes being cast in favor of the resolution. Only then the second one can be taken. And also, this is a resolution which will have a validity only for one meeting, because it says the intention to move such a resolution is moved at the meeting where it is proposed to be considered. And 162.2 is not a standalone provision. It basically says any resolution passed in contravention of 162.1 will be void. So, I fully agree and second what Sudhakar just mentioned. The only exception to this is with respect to proportional voting through a single transferable vote, which in India, I don't recollect a single company having availed of this.
This requirement of submission this is a requirement of submission of procedural report within 48 hours. If suppose company is NCD listing, so is there any difference between equity listed and NCD listed, or would be treated as listed only?
So with respect to LODR, listed means you have listed your designated securities. LODR refers to the term designated securities, and designated securities is also a defined term where it says it will include specified securities and NCS, non-convertible securities. As you know, earlier we had ILDS, preference share was separate. Everything has now been combined, and we now have the NCS regulations, which includes the non-convertible debentures as well as preference shares or any other instrument which is non-convertible in nature. So if you have issued non-convertible debentures or preference shares which are listed, you are a listed company. You could even be a private company, private limited company, which has listed debentures. You would then fall under the definition of listed company. Now, question is, under equity listing, it is 44 which is relevant, and with respect to debentures, it will be the Chapter 5 regulations which will have to be considered. But answering your question, will it be considered as a listed entity? Answer is very much yes. Even if it is debentures, it will be considered as a listed entity.
Thank you, ma'am. Thank you. Thank you.
Yeah, please go ahead.
Right. So withdrawal or modification of resolutions which are already voted upon. So para 10 states the resolutions proposed for consideration through e-voting, they shall not be withdrawn. Resolutions on matters that will also cause any kind of market turbulence, they also cannot be withdrawn. So para 12 states no modification to be allowed on resolution put to vote through e-voting process. Reading of qualified reports or ban on distribution of gifts. So para 13.1 and 13.2 states that qualified reports of auditors, secretarial auditors, to be read out at the meeting, and members' attention should be specifically drawn to management's comments. It cannot be taken as read. And para 14 states that there is no bar on provision of discount coupons to members, whether they are attending the meeting or not. So when we say this, there is no ban on the provision of food boxes or soft beverages under this provision. So these are some of the amendments which have been there as per the revised SS2.
Kanchan, just to go back to one slide. See here, the qualified reports, auditor, secretarial auditor to be read out, it has been put very specifically, because what happens is, there has been a practice that stating, chairman will say, okay, the secretary auditor report is taken as read because it has been already circulated. So here that cannot be taken as such as a read, because especially if the comments are there, qualifications are there, that is number one. Number two is again management comments. The question is, after the receipt of the auditor's report, whatever the qualification, observation, etc., the comments has got to be incorporated in the board of directors report. And if it is not there, then it is definitely a non-compliance. That will be taken very serious issue, because there have been actually action, as Sudhakar has put it. They have been now scrutinizing the things, etc. And there are a lot of cases which has actually come. Even I know a case where the matter actually landed up in one of the Supreme High Court, because it was one of the independent director who was appointed as additional director by the board. During that period, he was actually additional director. And that particular company, they have not made a comment on the qualification of the auditors. So notices have been issued. Ultimately, what happened? The managing director, company secretary, other director, they have actually pleaded guilty, and they have actually levied penalty, whereas the independent director said, action cannot be taken against me. I am no way responsible. He has moved the matter further to the High Court. Very interesting question which has actually come in that case. The designation of the director is very much important at that particular time to see whether he was an independent director or otherwise, because he was only additional director. When the board appoints, you appoint only the additional director. But when you actually make them in the regularization in the annual general meeting, then you have to actually put appropriately whether he is a chairman, executive director, non-executive director. Again, within that, again, independent director or professional director or promoter director, etc. If the selection has not been done, then he remained for all the practical purposes only additional director and director. This issue was very much discussed in all the High Court. The judgment has come. He asked for the quashing of the petition. Quashing did not happen. They told he has to prove in the trial court what capacity he was actually appointed. That is very important. So it has to be decided. So here the company secretaries have to be very, very careful in dealing such matters, because as soon as the secretarial auditor or cost auditor, strategy auditor report is received, you'll have to go through wherever it is required, the comments from the management is required to be incorporated. That is the duty here.
Absolutely.
Yeah, go ahead.
Yes, sir. So some of the revisions made in SS2, I tried to highlight them. But I think most of these we've also discussed through the previous slides. In case of companies having a website, the notice issued shall simultaneously be hosted on the website till the conclusion of the meeting. An instrument appointing a proxy shall be in the form which is prescribed under the Act. So I would like to understand a little on the provisions of proxy in the remote e-voting process from the panelists.
So Kanchan, this point on proxy, you have rightly raised it. Let me just divide the whole question under two heads. One, of course, the term proxy itself has been given a dual meaning. One, the instrument has been named as proxy, and it also says the person who is appointed, wherever the situation so permits, will also be called the proxy. Anyway, that's just a question of explanation, and all of us are very clear as to who a proxy is. So that is okay. Now the question is, we were all along looking at a situation where the proxy would only come physically to attend the meeting. Because of the pandemic, we were confronted with a very different situation where people could sit in the confines of their houses and participate in meetings as well as vote at the meetings. Now, where a person is unable to attend, the law has provided for a proxy to attend. So the very purpose has got diluted when he is able to attend by sitting in the confines of his own house where he is not required to move out. And therefore, in the context of meeting through VC, the circulars issued by NCA have very clearly stated that provisions of proxy will not be applicable in case a meeting is held through VC. And rightly so, because the objective of permitting a person to appoint a proxy is not there. So in the context of VC meeting, proxy is one who cannot be appointed. Proxy right of appointing proxy cannot be exercised if it is a VC meeting per se. Now let's go to the next point of e-voting. Now in case of e-voting, what happens? In case of e-voting, of course, if you have a physical meeting, the right of a person to be present as a proxy to attend the meeting is of course there. However, as has been seen, wherever there is e-voting facility given, the number of proxies that a company normally receives has gone down considerably, because you would typically have individuals appointing proxies. In case of this corporate, it's only 113 which is applicable, and that's not a proxy. So a person who's authorized under 113 may have granted a proxy, because a person authorized under a 113 resolution is entitled to exercise all rights of a member. So in the context of VC meeting, there is no relevance to proxy. In the context of e-voting, the relevance of proxy has gone down, in the sense that the number of proxies received by companies has certainly gone down as compared to what it used to be earlier.
Just one line I would add, I would like to add further is that appointment of the proxy by a shareholder is having an inherent right under the Act. So, but in the virtual meetings, it has been dispensed with by way of the circulars of MCA. So you cannot simply ignore the fact in mentioning in the notice. You have to mention very clearly in the notice, in case of virtual meeting, the appointment of proxies is dispensed with by virtue of the circulars.
That's correct.
Yeah.
In fact, this point of appointment of proxy was discussed in great details with the ministry, because if you refer to the provisions of 105, which deals with proxy, you are required to give at least 2 days, because at least 2 days before the meeting, the proxies can be received, 48 hours before the meeting. And when you are referring to 2 days for posting, then the person has to receive the notice, only then can he appoint. So therefore, initially, if you remember, the ministry was of the view that a shorter notice would mean at least 5 days notice, because the right of proxy cannot be done away with. Right of a shareholder to appoint a proxy cannot be done away with, which is the reason, after a lot of discussion, it was said that if, in the context of wholly owned subsidiaries, the discussion had happened where it was said that if all the shareholders agree, why not hold the meeting, at shorter notice without having to comply with this? It can even be held on the same day, which when it was explained, it was then accepted, which is the reason the Secretarial Standards has now provided for a very good enabling provision, saying that with the consent of all the members, you can convene a meeting at a shorter notice, even on the same day.
So, just for the sake of clarity, if you want to hold a meeting on the very same day or the next day, that means before 48 hours, you have to have 100% consent 100%. Of the shareholders.
Absolutely, 100%.
If you are doing with 95% consent, then you have to give that proxy for the 48 hours time to the proxies.
Right.
This is the finer point which one has to understand.
That's right.
Even though
so a new clause has been is being introduced for President of India or the Governor of State for appointment of a representative and for corporations to authorize their representative so they can participate in a meeting till on or before the close of e-voting. In case of remote e-voting, the letter of appointment of the representative of President of India or the Governor of State or the authorization in respect of the representative of corporations shall be received by the scrutinizer or the company on or before the close of e-voting. So proposing a resolution at meeting. Every resolution except a resolution which has been put to vote through remote e-voting on
March 1st nunchi naku class
Yamini, can you put up your mic, please? Yamini.
Almost మనం 15వ తారీఖు
I request all the delegates here who are attending to please mute yourselves.
Yamini, your mic is on. Can you mute, please?
So like we were discussing, every resolution except a resolution which has been put to vote through remote e-voting or on which a poll has been demanded will be
అన్నిటికీ అప్లై చేసేప్పటికి అంటే అన్ని చెక్ చేశాను.
Yamini and Magesh, why are you talking each other? Please put up your mic, please.
ఇందులో 3 నేను అప్లై చేసుకునే అంటే ఎలిజిబిలిటీ
whoever has the host rights, I think they can also mute the participants here.
యాక్సెప్ట్ చేస్తున్నాయని చెప్పిన యూనివర్సిటీస్ నే నేను ఇది చేశా, రీవెరిఫై చేస్తే అందులో సమ్మర్ ఇంటెక్స్ లేవు.
Yamini, can you put up the mic, please?
5-6 కొన్నేమో ఫిల్ అయిపోయినాయి అప్పుడే. సో వీఆర్ నాట్ అంటే క్లోజ్ ఫర్ మే అంటే సమ్మర్ ఇంటేక్ అని చెప్పి.
Hiral, can you put the mic of Yamini from your side?
I don't have the host rights, sir. I think Sudhakar sir has the rights. Sir, can you please check if we can mute?
I don't have that. In fact, I'm trying to contact the Saddam and the admin, and I will.
మెయిల్ పెట్టాడు. సారీ క్లోజ్ అయిపోయింది సమ్మర్.
I don't know. Somehow that she's not listening only.
Okay. So Nidhi is here. They are not required to provide the e-voting facility to their members. Moving ahead,
Magesh and Yamini, please put up the mic, please. It is my request.
Sir, ma'am, can I have one question?
Magesh, can you put up your mic?
Sir, I have one question. That's why I unmute myself.
Okay, please raise your hand so that we can know. Yeah, go
Okay,
ahead.
sir. Okay.
Yeah.
So even though, sir, a meeting is called through VC and someone is, let's example, hospitalized and would like to appoint proxy, so what would be the situation? Is it allowed or how, like ma'am that mentioned?
Not allowed. If it is a meeting which is convened through VC, the circular is very clear that you cannot have the requirement of proxy has been dispensed with. So if you opt for the benefit which has been granted by the ministry during the pandemic, which has now been extended right up to the year end, that is calendar year 23, then you have to go by all the provisions which are covered in that, which means you cannot have a proxy. You also need to give proceedings report, which will also cover ordinary resolution, as was brought out very nicely by Mr. Balakrishnan at the beginning of the session.
Yes, thank you.
should I move ahead?
Yeah.
The scrutinizer will submit the report within 3 days from the date of meeting to the chairman or any person who is authorized by him, who shall countersign the same and will declare the result of voting with the details of number of votes cast for and against the resolution, also the invalid votes and whether the resolution has been carried or not. The scrutinizer shall submit the report within 7 days from the date from the last date of receipt of postal ballot forms to the chairman or any person so authorized by him, who shall countersign the same and then declare the result of postal ballot on the date, time and venue which is specified in notice, along with the details of the number of votes cast for and against the resolution, including the invalid votes and the final result as to whether the resolution was carried or not. So then we briefly can talk about the minutes books. They shall be kept at the register office of the company, and a company may maintain its minutes in physical or in electronic form. The time of conclusion is not required to be maintained in the minutes of general meeting. So preservation of minutes and related papers. Minutes of all the meetings shall be preserved permanently in physical or in electronic form. Office copies of notices, scrutinizers' report and related papers, they shall be preserved in good order in physical or in electronic form for as long as they remain as long as they remain current for 8 financial years, whichever is later, and they may be destroyed thereafter with the approval of the board.
Hello.
Yes.
Hi, ma'am. I have one question regarding maintenance of minutes. So, for example, if there is a situation wherein a company secretary is being appointed and he is maintaining the minutes of his duration for whatever tenure he is, but somewhere management or the board of directors, they tell him to prepare minutes of backdated time. Like before 2-3 years, there was no maintenance of the minute. So, in that situation, how can company secretary protect his interest? Because then there will be tampering of minutes, and he's not responsible for whatever previous tenure minutes were to be made. So in that case, what a company secretary can act? Because if he directly says no, then there will be aggression from the side of the management. So how to get protected from that situation? What do you suggest, please?
It is not about protection. It is about legal compliance. You cannot do anything which is backdated, period. So, you
See, the only thing is I would like to add, Savithri, whatever you said further, rightly so, is that it is the responsibility of the company secretary to be able to explain to the management.
Absolutely.
That if you are fudging the minutes, what is going to be the repercussions of that? It amounts to a fraud. Please explain that section 447 and 448 to the company, to the management. Then they will understand that. Sometimes what happened is, fortunately or unfortunately, company secretaries, they themselves are not confident about their knowledge. They are not able to trigger the sections. They are not able to articulate before the management. I strongly feel this thing. They say that, if the company is asking us, the management is asking us, that doesn't mean you budge. No doubt about it. We all want our secured jobs. That doesn't mean that we are not able to say anything to the management. That's why Mr. Parekh, who was the chairman of HDFC, in one of the meetings, he said that company secretaries should develop this speak up culture.
Okay.
Right. Thank you so much, Sudhakar sir. Okay. So if we, sir, I would like to add one more thing. Like if we think with the perspective of a company, like they do not have minutes for previous 2-3 years. So with the view of company, what is the solution for them? Like if company secretary should not do the backdated work, but they do not have the previous record of 2-3 years. So in that case, what will be the way out with the perspective of company?
Compounding.
See, if at all you have to have that kind of a job, you joined a company for whatever the reasons it is, the minutes were not prepared and you are preparing those minutes, please ensure that whatever you are recording the minutes, number one, they're all substantiated with the documentation. Don't do anything without documentation. How you will be able to write the minutes, you tell me? You should be able to write the minutes only of what had happened. How you will come to know about the forms, what they have filed and other things. So you have to have documentary evidence. Please never ever prepare anything without documentary evidence. That is my advice to you.
Thank you so much, sir.
Madhur, only one thing can be done.
Yes, sir.
First thing is not maintaining the minutes is a total non-compliance. Whatever the non-compliance is there, they don't actually go for the compounding. That is number one. Number two, in the interest of the company, you need to have the records. Now, what you have to do is you have to take a search from the ROC and find out what has happened in the past 2-3 years. What are the various forms have been filed by the company, appointment has taken place, issues have taken place, etc. All, as Sudhakar puts it, collect all the documentary evidence. Based on that, make a summary of what is happening in the last 2-3 years. Put that in the next board meeting get that as approved, saying that for the last 2-3 minutes, somehow that the company failed to maintain the minutes. But based on the record, which are actually filed with the register of companies, based on this, these are all the happening, which we have recorded for the purpose of maintaining the records. Get it that approved in the board. That is the only solution which can be done. Nothing else can be done.
Perfect. Thank you so much, sir. Thank you so much.
So moving ahead, non-adherence of secretarial standards. If any violation of section 118 subsection 10, that is non-observance of secretarial standards with respect to general and board meetings is seen, the penalty for the default in complying with the provisions is as follows. The company shall be liable to a penalty of 25,000 rupees, and every officer of the company who is in default shall be liable to a penalty of 5,000 rupees. So some of the case laws here, which we can discuss, Polaris India Private Limited versus ROC of Delhi and Haryana. So the case is pertaining to the non-compliance of secretarial standards SS1 and SS2. The company has failed to comply with SS1 in respect of holding at least 4 meetings of its board, as well as the gap between the board meetings held in the calendar year 2019 and 20. And the order was passed by the ROC on 30th of November 2021. So for this non-compliance, the penalty was imposed by section 454 of the Companies Act, where the company was fined for 50,000 rupees, and the MD, past and present, whole-time director, the past company secretary, current company secretary, all of them in their individual capacities, they were fined an amount of rupees 10,000 to 15,000 each. So the total penalty for the non-compliance came up to 1.6 lakhs for the company.
No, not 1.6 lakh for the company. For the company, 50,000 rupees, rest of us to be
Right, sir, right.
out of their own pocket.
Yes.
Total penalty is 160, I agree,
Yes.
but not for the company. Yeah.
Yes.
That's true.
So another case, in the case of India Bulls Real Estate Limited versus ROC of Delhi and Haryana, again for the same non-compliance of SS1 and SS2, the company secretary and all the KMPs, they were penalized for not numbering the attendance register, and as well as not getting it bound at periodic intervals. Now this order was passed again on 30th of November 2021, and the penalty that was again imposed in this case under section 454 by the ROC, the company was penalized for 25,000 rupees, and each of its 4 directors back then, they were fined for 15,000 rupees each, along with their, again, CFO and the company secretary also, who were fined in their individual capacities. So even for such a thing which looks too small, but still the penalties in today's time are huge. So to the tune of 1.6 lakhs, the company and the directors, they had to pay.
In fact, I remember that when this secretarial standards were facing under severe criticism, one of the topics at that point of time was about the attendance register only, about the binding the attendance register at periodic intervals. So people used to make it, they used to mock it actually that, why to bind it, how the ROC will come to know whether you got the bound or not, and all other things. Now you say for such a small thing, and they have to face the penal provisions. So that's why we should never think that anything under the law is not small. And sometimes the small things which we are ignoring, they will catch up your neck.
One more thing, what happens, Sudhakar, in many companies, the company secretary, they think, okay, I'll assign the job to some junior fellows. Oh, you do the numbering. If that fellow has done the correct numbering or wrong numbering, missed out the numbering and other thing and all, this never checked back. We take it for granted. So here, all right, you can get the job done by somebody doing the numbering, but you yourself has to go through whether it is correctly done or not. That exercise is required to be done. Otherwise, it is very difficult. That is where our role is really, really coming. And I know in many of the companies, they always have, most of the companies, they have what you call that maker-checker rule. Somebody does the job, other person actually checks it whether it is correctly done or not correctly done. So that sort of the mechanism need to be there. As Kanchan puts it, is a very trivial issue, numbering and not binding. But the thing is, periodically, he should have actually checked them, exercised the control, then, such situation would not have arisen. Yeah.
So, Kanchan, your presentation is over. Am I correct?
Yes, sir. This is just the last case law, that's all.
So, Savithri, now may we request you to please deal with the virtual meetings and the nuances of that. That is very important for us.
Before I go to the virtual meetings, few of the points that I would like to address are with respect to rights of the preference shareholders and debenture holders. There was a bit of a discussion on that as to whether the debenture holders and preference shareholders are entitled to notice of the meeting. Assuming the instruments to be listed, if the preference shares or debentures are listed, then by virtue of the amendment which came into effect from September 2021, the debenture holders as well as the preference shareholders, now they are called non-convertible security holders, they will be entitled to notice of the meeting. This is under LODR in Regulation 58. There is a specific provision requiring us to give notice, requiring the companies to give notice to the preference shareholders and debenture holders, provided these securities are listed. The next question is with respect to the proceedings of the AGM. The result of voting is covered in 44. However, proceeding of the AGM is also required to be given by equity listed companies, and the same provision is also applicable to non-convertible securities which are listed. This is also covered in Regulation 51(2) as well as in Schedule 3. So therefore, proceedings will have to be filed with the stock exchange within 24 hours. There is no specific provision for giving results similar to 44 because 44 is not applicable to non-convertible securities. Also in the chat, there was one question as to whether LODR can go beyond what is given in Companies Act. Let's not look at it as going beyond. It is just that if you have opted for listing, you need to also comply with LODR requirements. And if LODR requirements are stringent, automatically by complying with the stringent requirements, you would have automatically complied with company law requirements.
And also, I think LODR is not a subordinated law. It is a law in itself.
Absolutely. Yeah.
No, clash in the sense, you see, these are two different regulations. When you say two different regulations, because you are the registered in the Companies Act, you are anyway comply with the Companies Act. When it goes to LODR, you have specifically agreed that you will comply within this day. That is the agreement with them. So naturally, whichever the stringent, that will prevail. There is no question of talking whether this is supreme or this is supreme, which is to be complied. There is no question at all. Because the moment you comply within 2 days, it is automatically complied within 7 days, as Savithri Madam puts it. That's it. Because you have to comply with the both. Because this is an agreement specifically with the stock exchange, and that is the regulation. So you have to comply with the both. So how do you comply with the both? One of the stringent. That's all. Simple.
There was one more point, which was a very valid point relating to para 12 of SS2 on modifications. In fact, modification and rescindment of resolutions is something which I would like to cover very briefly. Modification, can you do a modification of a resolution if the notice has already been issued? In fact, the question was in the AGM notice, should we just refer to the resolution to pass without modification the following resolution as an ordinary resolution, or should we just say to pass the following resolution as an ordinary resolution, was the question that was raised. Here, I would say that if the meeting is going to be held physically and the company has the flexibility of voting through show of hands, please ensure you retain the flexibility and write with or without modifications. If the meeting is going to be conducted through VC and you're going to be passing the resolution by having show of hands because the company has the option of having show of hands, voting through show of hands, please retain the flexibility of with or without modification. If it is a listed company which is required or a company which is required to provide e-voting facility, the option is available to include with or without modification or not to include. Both are correct. Why am I saying this? If you refer to para 12 of SS2, it says that in the case of votes which are placed for e-voting, placed for voting through e-voting, in the case of resolutions which are placed for voting through e-voting, you cannot modify after the resolution has been put to vote, which is you need to give e-voting for maximum of 5 days, minimum of 3 days. So if your e-voting period has started, sorry, you cannot make any modifications whatsoever. But let's assume you had issued the notice and after 2 days, you found that there was a small clerical mistake and you want to correct it. If you have not written with or without modification, then there could be a discussion and debate. Of course, there is still another provision where, at least 14 days before the meeting, if you have given the amended resolution to all the shareholders, that would also be sufficient. But at the same time, when you're filing your forms, the question would arise as to whether notice was given with 21 clear days. Answer is yes. Whether there was an amendment, there is this particular thing. But if you have not retained with or without modification, you cannot make any change in the resolution. So therefore, in case of listed companies or in case of companies which are required to provide e-voting facility, you will have this particular option of either writing with or without or not writing. Both are absolutely correct. Similarly, with respect to modification, what is the scope of modification? You cannot make any material change in the resolution. However, a small clerical change and all that can be made. There is no problem whatsoever. And anything which changes it substantially is something which will be frowned upon. The other point here is rescinding of a resolution. In fact, you all would recollect in the case of HDFC in the year 2018, they had 2 resolutions which became infructuous and therefore were not transacted at all at the AGM, and their proceedings very clearly provide for proceedings very clearly state this particular situation, and even in the results in 44 they have not covered these 2 resolutions and the rest of it has been covered. I would say that this was a right approach in the sense that they have gone by the spirit, because if you go by the provisions and it says you cannot rescind it, then it means that you cannot remove anything, but cannot rescind it only when the resolution is valid. Let's say, for example, if there's a resolution for appointment of a director and God forbid the person passes away before the meeting, what do you need to do? You cannot issue another resolution saying that so-and-so resolution not to be considered at the meeting. It has become infructuous. You just need to mention it and remove it in your results. So, but at the same time, maybe in the subsequent guidance note, we could just consider these kind of situations also. I would place the thought with Sudhakar. I would just briefly touch upon, since I have 2 other panelists also whose views I'm also keen to listen to. With respect to e-voting facility, with respect to VC facility, in fact, it is something which has also been recommended by the committee, and therefore all of us are hopeful that this would be a permanent feature, and therefore holding the meeting through VC facility with respect to general meeting. We have these circulars where the necessity of filing of, you need to provide the facility, and the circular says not less than 1,000 persons, which actually means there would be a mix between a webinar facility and a 2-way communication facility. And 2-way communication, most companies would want to ask the details from the shareholders as to who wants to participate as a speaker. Now, this is important because if a person is sitting in a remote village where the connectivity is poor, you cannot be holding back. I mean, We saw it very briefly in our own meeting, where for the presentation we did have to wait for some time. Just imagine a proper meeting where you have the directors and the chairman and others. You cannot be having interruptions, which is the reason it is but fair that the company would ask the shareholders to specifically intimate beforehand, which is exactly the way it is done. And the shareholders can then give their names. They could get the connections tested, post which they speak at the meeting. With respect to the presence of the directors, with respect to question and answer and the proceedings, everything goes on as usual. However, there is a further requirement to also submit transcript of the proceedings with the registrar of companies, and this is also filed with the ROC, apart from MGT 14 being filed. Since there is no specific form that has been prescribed, it is the same MGT 14 which is filed with respect to the proceedings at the meeting. So with respect to VC, these are the other additional points, and of course if there are specific queries on VC meeting, I would like to take them on board. There's another point which I would like to mention in the context of Companies Act and LODR. Companies Act very clearly refers to clear days notice to be given. If you refer to LODR, it does not refer to the term clear days. However, going by Schedule 3.23, where every notice letter which is issued to the shareholders is also required to be given to the stock exchange, the companies would ensure that they give the AGM notice on the stock exchange portal, upload it on the stock exchange portal, and thereafter give it to all the shareholders. I would also like to add one more point here. It is commonly understood, legally recognized, and has also been clarified by the by SEBI, that anything which is uploaded on the stock exchange site will be set to be publicly available. Once it is publicly available, the protection of accidental omission can also be claimed. Now, when I use the word accidental omission, it should be one which is accidental and not intentional, which means you have taken all steps to send it. Let's say, for example, at the recipient's end, the emails were not going through because his email box was full or whatever. It's not an omission of the company. The company has done everything that is required to be done by the company, plus has also put it up in public domain by putting it up on the stock exchange site. So this would be a great protection where you have done it at least 21 days before the meeting. Now, the term clear days is applicable whether you're holding a VC meeting or you're holding a physical meeting, because that is a specific legal requirement with respect to holding of a meeting. Now, if it is a VC meeting where you would only be required to send by the notices through email, then in such an event, and it's a very good move because we are actually going green. We are looking at sustainability, environment protection. All this basically requires that you send everything by email. And also we have the 3rd November 2021 circular, which specifically requires the shareholders to give their email addresses. So when you're sending the notices through email in such an event, the notice is deemed to have been issued to all the persons whose emails are registered with the company, with the registrar, or with the depository. Now, this is an interesting point where it says depository. Now, depository actually gets it from the depository participants. So it's actually depository participants who have got it registered. Depository is only a repository of all these records, but that's what is actually meant. So therefore, depository participants, registrar, company, or with the depository, in such an event, your notice has gone. Now, how will you interpret 21 clear days? 21 clear days here would mean 21 plus 1 for sending of the notice, the day on which you're sending it by email, and the date of the meeting. So therefore, it will actually become 21 plus 1, which is 23, and not 25, because 2 days to be added for dispatching it by post is not required in such an event. I would pause over here and would hand over to Sudhakar. Over to you, Sudhakar.
Savithri, I have one doubt with me rather.
Sir, you're on mute, sir.
Yeah. I was just asking Bala, he is the moderator actually. So now he may take up the questions which are there in the chat box.
Yes, sir.
Savithri,
Yes.
I have one small doubt actually.
Sure.
When we are talking about the VC meeting,
Right.
there are various meetings which are actually held in cloud-based.
Correct.
For example, the Zoom meeting, what we are holding is actually cloud-based.
Right.
Adobe meeting, Google meeting, all this cloud-based is there. The cloud-based meeting is there actually. And where the companies are also have their own server, etc., where the recording, etc., and other things are all done. When we talk about the VC meeting, is the cloud-based meetings also possible to have the VC meeting?
Absolutely, yes. Because cloud is only a technology. And in the context of cloud, one could have a doubt as to whether you're holding the meeting in India or not. Because that's one of the provisions covered in 96. Now, here the point is, that is exactly the reason why deemed venue of the meeting has been provided. And the deemed venue will be the registered office of the company. And cloud is only a technology whereunder they are providing you the space to host it there. In case of small companies, or for that matter, I would say small and medium-sized companies may not want their own server space to be owned by them because that's pretty expensive. So to answer your question, is it permissible? Answer is very much yes. Although there could be a small ticklish issue from a section 96 perspective on holding of the meeting in India. But from a VC perspective, there is no bar. And since the government is entitled to give relaxation, there's absolutely no issue whatsoever.
Okay. Then the next thing which comes to my mind, in the general meetings, all the documents are to be made available for the inspection of the shareholders.
Right.
Now, physically, what we do is we keep everything open. We actually declare also the article of association, books of accounts, everything is open throughout the meeting. It is available for inspection. Now, I can understand in case of the people who are making the electronic records, which can be definitely made available for the people to view or having a website, etc., and other thing and all. But the companies which do not have the electronic storing facility, okay, then in such cases, how do we actually ensure this compliance? What is the methodology? Because I think there will be some methodology that will be there, but I'm ignorant on this, really speaking. That is why I'm seeking this.
So, technically speaking, while a company can say that inspection would be given at the registered office of the company, I would say that would not be right, because you are availing of a VC facility which is completely technology supported. You cannot ask someone to come from whichever place to come to the office physically and take inspection. So if you're holding it through VC, it is but fair that you give inspection through the net. So, it's not even necessary that, when you say it is available for inspection, it should be available for you to give inspection to the person concerned. So one way of doing it is you just host it on the website and allow everybody to see it. The other way of doing it is give them the option of seeing it maybe on a Zoom call, maybe on a Teams call, or on a WebEx, as the case may be.
No, what normally companies do is, Bala, that they create a data room. In the data room, they provide all the documents. You have to, scan the documents, whatever the relevant documents are there. You have to put it in the data room, give the user ID and password to the concerned shareholder who wants to inspect the documents. Because as Savithri has rightly mentioned, during the COVID period, people cannot travel from one place to another place. That is the reason why virtual meetings are there. Even if tomorrow, if the hybrid meetings are permitted also, that point of time, creation of data room is very much required.
Absolutely.
This is how it has to happen.
Okay, so that is making the data room available, and even the scanning document, even though it is not digitally maintained, that is possible.
Absolutely.
Okay.
In fact, let me tell you that during the period of 2020, the secretarial audits, financial audits have taken place on the basis of data room only.
That's right.
Yeah, okay. Let us run through the chat box so that we can take the questions. I think so. only intimation to the shareholder to change the venue of the meeting is required, or the consent of the shareholders will be required for change of venue?
So for change of venue, if you are changing the venue sufficiently in advance, intimation.
Intimation is only required, I think. Consent is not required, because if you are changing the venue, the only thing is you have to give the intimation in sufficiently in advance, people to enable to attend. That's what I think. So, yeah.
Yeah. Let's say, for example, let's take an extreme case just to understand a simple issue. Let's assume the venue where it is proposed to be held, that building collapses, or it is completely flood affected, or is rendered unsafe by the municipal authorities. You definitely will be changing. But if it is an intimation, but you should ensure that the intimation is, one, given to all the shareholders to whom the notice was sent. Two, as a good practice, publish it in the newspapers also. Three,
in fact,
if you are listed.
Sorry, Savithri, in fact, this particular issue has been elaborately explained in SS2. In case of any force majeure reason, if the AGM is being postponed, if it is less than 3 days, you don't need to send the notices to all the shareholders. You have to simply, one representative of yours should be there at the venue of the meeting. If any shareholder comes there, you have to physically inform them. At the same point of time, as you rightly mentioned, you have to give a public notice. Suppose if you propose to hold the meeting beyond 21 days notice, beyond 21 days, then you have to give a fresh notice of the meeting to all the shareholders.
True, absolutely.
Whether SS2 will be applicable to Section 8 companies, obviously Section 8(2) companies not applicable, but however, the company law provisions has to be provided for general meeting. I think Kanchan has already taken up this. Is the notice of AGM required to be sent to the preference shareholders? I think we discussed this. Savithri Parekh explained this really on this point. But one thing is there, in case of the preference shareholders, if the arrears of dividend is remained beyond 2 years, etc., they get the right to vote in the meetings. In such situations, probably you have to give the notice to them, because if they get the right to vote.
According to me, AGM notice is to be sent it to all the members of the company, and preference shareholders also members of the company only. You have to send them the notices. Only thing is that they may not have the voting right. Can they attend the meeting? Technically, they can attend the meeting, but they will not form of the quorum for the purpose of the meeting, because they don't have the voting right. As you rightly said, if the dividend is not paid for a period of 2 years, they acquire the voting right. At that point of time, they may become part of the quorum also. Savithri, you may explain your views, please.
Sudhakar, I 100% agree with you. I only have another small point to make over here. Let's assume it is a company which is providing e-voting facility. E-voting facility will only be given if you have ISIN of the respective securities. Now, let's assume a company has 2,000 equity shareholders and 10 preference shareholders, and this company has the same 10 preference shareholders have continued. You will necessarily have to ensure that you take ISIN for the preference shares. Otherwise, it will be difficult to get e-voting facility. Or of course, you can even treat them as physical shareholders and create, but for even, you will need to get e-voting number from the entity which is providing the e-voting facility platform, because those preference shareholders ordinarily would not have got e-voting facility earlier, but the year in which they are getting, you will have to treat it as a separate security, and voting will accordingly have to be reckoned. So that's something which will have to be borne in mind. And I agree with you, Sudhakar, that preference shareholders are members. Notice is required to be given. Absolutely.
In case of a private company, do we require to have a roll call for the shareholders? Yes, obviously, because any VC meeting, you'll have to take a roll call.
No, sir. No. Sorry. In fact, roll call is required only for the board meetings. Roll call is not required for the general meetings.
Yeah, that is right. I think I'm not talking about that roll call. I'm talking only board meeting here.
Right.
Because when you say a private meeting, but a general meeting, it is not. Because he has just to put only the roll call. That is right. Yeah.
Okay.
in case of the physical meeting where one director is joining virtually, so the director should state the roll call.
In fact, Bala sir, that one thing I want to brought it to the notice of the participants.
Yeah.
Most of the times, sometimes recently somebody has asked me a question that in case of the virtual board meetings, some of the directors are not switching on their videos. What we have to do, despite the fact the company secretary is requesting them to switch on their videos, still they are not doing that. In fact, technically speaking, it becomes only a teleconference kind of thing. If you are not switching off the video, it is not a video conferencing meetings. So the answer to that is, at least at the time when he is giving the roll call, when they are voting for the resolutions, that point of time, according to me, the company secretary has to insist that they have to switch on their videos. Otherwise, he should not allow the meeting to air. He has to explain this to the chairman, and the chairman has to request the directors, whenever they are taking the roll call, switch on their videos. Whenever they are passing the resolution, they have to switch on their videos.
In case of a physical meeting where one director is joining virtually, so that director would state the roll call. Any contradictory view on this?
So actually, in case of a board meeting, if one director, see, in the act, or rather I would say in Rule 3, there is no clear distinction between what is a board meeting through VC. That is, there is no distinction between a physical meeting where quorum is present and only one person is attending through VC, vis-a-vis a situation where all the directors are participating through VC, or rather all directors forming quorum are participating through VC, which is something which, we had also asked for a clarification. They said they would not do it. And during the pandemic, we saw that all the directors were participating through VC. So in both cases, it is considered as one where you need to comply with Rule 3. Where you need to comply with Rule 3, roll call is necessary. So the director who's attending through VC will have to give his roll call, although he is the only person who's attending through VC in the board meeting, which is otherwise held physically.
In fact, see, as you rightly said, Savithri, that even when the physical meeting is taking place, only one director is attending through VC, still has to give the roll call. For one reason, actually, see, in the roll call, what is happening? He's giving certain affirmations. One of the affirmation is that he is able to see everyone and he is able to hear. Tomorrow, he cannot go back and say, look, I am not a party to the meeting because I am not able to hear anybody. I am not able to see anybody. Number one. Number two, he has to also give an affirmation that apart from him, no one else has access to the proceedings of the meeting.
Correct.
God forbid tomorrow, if anything happens also, he will be insulated. Otherwise, he may be blamed that you have enabled the others also to view the meeting or to part, whatever the proceedings are there. So roll call is very much required for the video conferencing meetings.
Actually, Sudhakar, you've also raised a very, very valid point with respect to no other person is present at the meeting and no other person has access to the proceedings of the meeting, because digressing from the topic of secretarial standards, we also have prohibition of insider trading regulations, where in the SDD, structural digital database, every person who has had access to UPSI, his name needs to be entered, and the person from whom he has got the information needs to be entered. So, if there is someone who accidentally comes into the room where the meeting, where this person is participating through VC, and that other person, listens to the presentation on financial results, you need to enter the details of that person also. And when the director says there is no other person, he is holding himself out and he is confirming that there is no other person. To that extent, the company would rely on this. This roll call is becoming very, very important now.
If votes received through the e-voting facility, is it sufficient to pass the resolution, but quorum not present at that time, then it was considered that resolution passed or not for that particular motion?
We discussed this particular point.
I think you elaborately discussed on this. I think we dealt with it in this.
That's right.
Whether the Companies Act, Supreme or SEBI Act, this also we elaborately discussed on this. I think this is okay. Comply with 2 days, 7 days. Why there should be contradiction of the SEBI LODR and the provision of the Companies Act? This we cannot answer the question here because the thing is always there has been, disharmony between these two regulations over a period of time. The harmonization take place. I
Sir,
think
let me add one more thing. It is not only the Companies Act and SEBI. Tomorrow, if you are regulated by any other regulations, you have to comply with that also.
correct.
If your company is a NBFC company, you have to comply, and it is a listed company, you have to comply with MCA, SEBI, and RBI regulations.
Absolutely, you're right.
If you are insurance company, IRDA regulations. If your company is a telecom company, telecom regulations. So you cannot say that all the why these acts are subordinated laws and all. Whichever the compliances on the higher pedestal, you have to go as per that.
Correct. There is no comparison which is supreme or something. No discussion at all.
Correct.
Sometimes we'll have to take always the safer approach and to follow the stringent provision. Oh, that is right. There's nothing. LODR subordinate, no, that also we have discussed. Is it right to mention in the AGM notice to consider passing the regulations or ordinary resolution, or we should consider passing it with or without? I think Savithri Madam has discussed elaborately on this. Can letter of authority from a foreign body corporate giving authority to an individual be sufficient compliance to attend and vote at general meeting or its Indian subsidiary?
So this is an interesting question. Now, if you refer to section 113, 113 is applicable not only to companies which are incorporated in India, but also to bodies corporate. Now, the term body corporate would mean any entity which is incorporated outside India will fall within the definition of body corporate, because if it was to be restricted to companies, this requirement would have been applicable only to companies, but it is applicable to body corporates. Now, there are 2 points here. One is an LLP under the LLP Act is also a body corporate. Second, entities which are incorporated outside India. Now, if you now look at it in the context of entities which are incorporated outside India, then such an entity will have to give one of the 2 documents, which is what section 1131A says, either a board resolution or authority granted by any similar authority, similar to which is the governing body of that particular entity. Now, when you say body corporate, let's say, for example, in case of a company which is incorporated in a country, like say, for example, Brazil. Brazil, you need not have a board with respect to certain companies. So there is a person called administrator who's supposed to be in the position of something similar to a manager, who would then grant the authority. And some countries, you would just have the articles of association, which very clearly provides as to who can grant the authority. Then that person granting the authority would be sufficient. For example, a place like Russia, again, you have an authority granted by a general administrator. So, you have to see as to which country it is in and what is the document. And based on that document, you would be able to go ahead. If it has a board and the authority has to be given by the board, you will have to ask for a board resolution.
And especially one thing I would like to say further to add what Savithri said, if you are any of the participants who are the practicing company secretaries acting as scrutinizers, your responsibility is under these circumstances to ensure that the authority given is properly supported by, the person who is giving that signing letter or whatever it is, backed by a proper authority. Otherwise, tomorrow as scrutinizer, you will maybe in trouble.
Register of contract is required to be signed by the directors present in the meeting. In case of the virtual meeting, how can this be complied with?
You can mention in the register clearly that he has attended the meeting in a virtual mode and no need to have the signatures.
Correct. The company secretary has to actually certify it that he was actually present, he has consented, that's what he has to record it, that is sufficient, that's what the law says.
This is mentioned in the guidance not very clearly.
Yeah, you're right. Can a proxy attend and vote in the general meeting of a private company if provides in this article of association by virtue of the exemption available through MCA notification?
If the articles so provide, then it is okay to attend.
The estimated actual place in the board meeting of the financial year needs to be signed by the chairman in the form MBP4. Do we need for, no, what is this? I'm not very clear. The estimate and actual place in the board meeting of the financial year needs to be signed by the chairman in the form MBP4.
That MBP4 is the Register of Contracts.
Okay, okay. Then I think we discussed this. Do we need to file the MGT 14 for convening the shareholders meeting through VC?
Of course, yes.
Yeah,
so
you need.
Yeah.
You need.
That's it. Yeah.
Is transcript the general meeting held through the VC to be submitted to the registrar?
Yes, you are required to. If it is a VC meeting, you are required to.
VC meeting, it is required.
Yeah.
Physical meeting, it is not, but VC meeting, it is required actually. Or it is only the resolution based VC meeting to be filed with the registrar in MGT 4.
No, transcript has to be given.
Transcript has to be given because MGT 4 is only for the filing resolutions.
That's correct.
And I think MGT, somebody has answered also, MGT 14 for filing resolution, MGT 15 should be filed for the proceedings of the meeting. I think that is correct.
In fact, only thing is that, Bala sir, that in the beginning of the meeting itself, we have mentioned about this. In case of virtual meeting, all the resolutions are to be filed with the ROC. Even your ordinary business resolution, normally it is not required, but still you have to file that.
Yeah, I said that.
Number 2 is the time period also is as against 30 days. Here it is against 60 days will be there.
How the quorum will be ascertained in case of the deemed public company for XABC Private Limited is a subsidiary of XYZ Limited.
For all the purposes, it is a limited company and you have to ascertain the quorum accordingly.
Absolutely.
Making transcript of the AGM proceeding public by filing the stock exchange's website would really make sense, because as many AGMs, non-relevant talks are more. For example, we know Asha Lata, a shareholder, here Saryat and other, we know the couple and other shareholders put always talk rubbish at the AGM. Also, many CEO, chairperson give over enthusiastic statement at the meeting. Is it advisable to make the transcript public? It should not happen like, as bail mujhe maar. First, we need to have the matured and an educated crowd.
So transcript is not required to be filed with the stock exchange. However, it has to be filed with the ROC. And talking of transcript, with respect to the specific questions of shareholders and all, there are two views on this. I would say that it is not necessary to verbatim reproduce everything with respect to shareholder discussions. I mean, you don't have to write the praises given by the shareholders in the transcript. It is okay.
In a private company, only 2 directors, and in the AGM, only 1 director is present. Is it okay?
No.
No, it is not. How can that be?
See, in fact, for the AGM, the presence of 2 physical members is required. In fact, though, if a shareholder who is representing a body corporate or a company, though he will be counted for the purpose of annual general meeting as a single member, if I am representing 5 companies, I will be counted as 5, but that doesn't mean I myself will hold a AGM. Another physical person is required to have an AGM.
Correct. One-to-one, you cannot have a meeting. We need to have somebody to have a meeting.
So even if the quorum for a public company required is 5, and I am representing 5 companies, but I cannot hold a meeting on my own, there is another single member, physical member is required.
Absolutely. So you can be considered as representing 5, provided one more person is there.
Yeah,
there is a
right.
decision of the court also.
Sir, in this case, only 2 directors were there and 1 director was present, and both directors are shareholder, and the 1 proxy was there. So is it okay? Because the 1 proxy and 1 shareholder, and the 1 shareholder, he himself is also director.
Meenakshi, proxy will not be counted for the purpose of quorum.
Okay.
It is very clear. Proxy is not counted for quorum.
Okay. Okay. Got your point, sir.
If a director want to attend an audio, can he be permitted and will be counted for the quorum? Absolutely not. He can attend, his views can be expressed, but the thing is, he will not be counted for the purpose of quorum. He cannot vote it. Because it is always an audio-video meetings. In case of the virtual board meeting, how the contract register signed, that we have seen already. Notice of 21 days mandatory even when Article of Association provides shorter notice, say 14 days.
In fact, just Bala sir, I would like to add 1 or 2 things here in case of this director attending the meeting through teleconference.
Yeah.
In fact, this particular issue we have discussed at SSB very great length. Whether the director can be permitted, first of all, to attend through teleconference or not. No doubt about it, as you rightly said, he cannot be counted for the purpose of quorum. He cannot vote at the meeting. But can he attend the meeting through teleconference? Does he have a right to attend like that and all? Because Act is silent about it completely. Certain time, what we have discussed, Savithri, correct me if I am wrong.
Right.
Act does not prohibit a person to attend the meeting through teleconference. So it is the chairman's discretion to permit a person, because why the board has to be deprived of, because that the particular gentleman is not able to attend the meeting through VC because the connection is not available. The bandwidth, suppose that particular place is not available. So he wants to attend the meeting through teleconference, will express his views at least. So if the chairman, in his discretion, if he permits to attend the meeting, yes, by all means, he can attend the meeting, but his, what's called, he will not be counted for the purpose of quorum. He will not be able to vote at the meeting. Another question comes, is it to be recorded in the minutes or not? Yes, it is to be recorded in the minutes because he is attending the meeting. He is expressing his views about the meeting. To that extent, yes, no doubt about it, it can be part of the meeting. The final question comes, can he be paid the sitting fee for that particular thing or not? It is again the same thing. Companies Act, nowhere it is prohibited that he cannot be paid sitting fees. It is the discretion of the company to pay it. But as a good corporate governance measure, if he has not paid, it will be in order. Good corporate governance measure. Legally, there is absolutely no problem. Savithri, you may add on anything to this, please.
Absolutely. I 100% agree with the views, Sudhakar. That's absolutely clearly explained.
Sudhakar, I 100% agree with you. In fact, I am a old timer. I am going back, way back to somewhere in 1990s when this virtual meeting and other thing and the COVID situation, which were all not there. In fact, we had about 3 overseas directors. 2 of the people were able to join for physical meeting, but one of the director could not join in the physical meeting. But he said, actually, I want to be the part of it since we are discussing the project, etc. I'll be able to join through the audio. That chairman actually said, he talked to me. I told him he can join, but only thing is he cannot be counted for the purpose of quorum. Then actually we provided the audio facility. Then he joined in the audio facility. As rightly said, we have taken his views. He has recorded his minutes also, what are the views he has expressed, etc. and other thing and all. But for the purpose of quorum, for the purpose of voting, we are actually excluded. I am talking about something 30 years back. So what you are saying is absolutely correct. It is up to the company to allow, take views. But only thing is, as law provides, quorum and things cannot be taken. Yeah.
In fact, for the purpose of participants who have not attended SS1 last week's webinar, let me also tell 1 or 2 things more for this. The question comes is whether the director has a right to ask for a copy of the recordings of the board meeting. The answer to that is no. He cannot ask for a copy of the recording of that particular meeting. At the most, he can say that I want to see the proceedings of the meeting. The video recording may be shown to him. Number 1. Number 2, if a director says that, look, I want to record the meeting, the proceedings of the meeting, he want to do the audio recording. No, it is not permissible. The chairman can say very well, no, I will not permit the recording. Suppose without informing anybody, if he records, what happens? If it comes to the notice of anybody, immediately he can be asked to delete everything. Because these are all not permissible things. A director cannot record the proceedings of the meeting without knowing the chairman or anyone else as such. Yes, sir,
just a small correction. In case of VC meeting, general meeting held through VC, the transcript gets uploaded on the website of the company. A small correction, please.
Yeah.
It's not ROC, but it is website of the company.
FGT 14 is
Hello.
applicable to the private company for transcript of the meeting.
Hello.
Yes,
Please.
yes, please, yes, yes, Mahendra.
Am I audible?
Yeah,
Hello.
yes, yes.
Yeah. So if a director is participating the meeting through teleconferencing, it is obvious that here that person will not be counted for the purpose of quorum. But if his advice or his suggestions is getting recorded in the minutes, yeah, that is good. But whether the sitting fees can be paid to that person, I don't think so.
Mahendra, as I told you that technically it is not prohibited. Governance point of view, it is not permissible because his presence is not counted for the purpose of quorum and voting. But
Right.
he is attending the meeting and he is participating in the meeting. So the company may decide to pay the sitting fees.
Okay.
Right.
Thank you, sir.
But
Thank
as a governance measure, if you say that, is it correct? Maybe as it's not a good corporate governance, so better not to pay. That's what I have mentioned also in my MA
Right.
earlier when I was expressing my view.
Yeah, you told, but it was not clear to me, so that is why I asked.
Legally,
Okay,
there is
thank
no
you.
prohibition. Legally, there is no prohibition.
Right. Thank you, sir.
See, the
Thank
same question, Mahindra, it has come earlier also. For independent directors meeting, can the sitting fee be paid to the directors or not? Same is the view there also is that absolutely it is not, there is no prohibition as such under the Act. Though it is not a committee meeting, though it is not a board meeting, independent directors meeting is a statutory meeting. If the company decides to pay that, they can pay, no problem, absolutely. And similarly, if the director who is attending the meeting through audio conference, does he have a right to claim the sitting fees? If the company decides not to pay, he has no right, legal right to ask for the sitting fees.
Right. Very clear, sir. Thank you.
Thank you.
MGT 15 is applicable to the private company for transcript of the meeting.
No, not applicable.
Private companies not.
Private companies is fine.
Hello, Sudhakar sir.
Yes.
Sir, as you said, sir, like director cannot demand the video recording proceeding of the virtual meeting of the board meeting. But in case the director is the chairman of the company's director himself, and during the meeting, does he require approval of any of the board of directors to see the proceeding of the meeting, or in his own discretion, he can directly ask the company secretary to provide the proceeding or to see the proceeding of the virtual board meeting? Or does he also require approval like other directors to see the proceeding?
No, he don't require the approval of other directors. Just like the way, if you want to inspect the minutes of the meeting, what you do, you approach the company secretary. I want to inspect the minutes of the meeting. Then what the company secretary has to do, he has to sought the permission. If he is permitted by under the articles or by way of a board resolution that he can give the inspection, he can do it automatically. Otherwise, he has to seek the permission of the chairman to give the inspection, and same is the case here also.
Okay. Thank you so much, sir.
In case of the general meeting held through the VC, the board of directors required to have the roll call or not? Yeah, this we discussed, roll call is required. If a director attending through only via teleconferencing, his attendance is not counted for the purpose of quorum. Also, he cannot. Yeah, this same thing is saying. Upon what time should the following documents should be available on the website of the company? In case, I think the question I am not very clear. Up to what time should the following documents should be available in the website?
See, any documents, a listed company which is uploading on the website of the company, there is an archival policy is there. As per the listing regulations, they are to be available for a period of 5 years. And in line with the archival policy of the company. If the archival policy of the company prescribes more than 5 years, you have to maintain accordingly.
In case the connection gets discontinued due to some unforeseen circumstances and it is not restored, can the meeting be adjourned? Chairman will be the meeting be treated as done with this meeting is not adjourned.
Yes, if the quorum is not there because somebody got disconnected and all quorum is not there, then you have to adjourn the meeting.
Yeah, meeting will get adjourned actually. Because a reasonable time, you can wait for the restoration of the things for maybe 5 minutes, 10 minutes, 15 minutes. But if it goes beyond that, I think you have to adjourn the meeting only.
So that's why company secretary has to ensure that sufficient quorum is available at all the times. Otherwise, it will be a problem, certainly.
Correct.
Absolutely. See, there are these questions regarding VC meeting. 2-3 other points. We will need to have one independent director and the auditor attending the meeting. You will need to start the connection at least 15 minutes before, the facility for entering the meeting room. Now, this is done for the, as Sudhakar has been rightly mentioning time and again, this is done to ensure that the company secretary is able to ascertain whether there is quorum or not, and also to ensure that there is a smooth transition. You cannot just start the meeting right at that time and expect that there is quorum. At the same time, people are bound to have some glitches, technical glitches. Hence, you start allowing people into the meeting at least 15 minutes before. It can be much earlier than that, but at least 15 minutes before. And mind you, e-voting facility at the meeting will also need to be provided. This has been very specifically stated. Needless to mention, appointment of chairman will be as is provided in the act. That is, if you have a chairman of the board, the chairman of the board would automatically preside as the chairman of the meeting. But if you do not have a chairman of the board, then in that case, you would be appointing based on the procedure which is given.
Also requesting organizers to have one webinar on IEPF, unclaimed share, escrow account, recent regulations, etc. as per the LOA, so as to much
We will do that, sir.
Yeah,
we will do that.
We take your
Sure.
suggestion. We'll go through it. We'll definitely schedule it. If the chairman of the company has his motive against the company, ill motives against the company, and time and again, the delay and create obstacle against the interests of the company, then in that case, what are other majority board of the directors can resort? For example, while roll call, chairman confirmed that there is no other person in his room. However, some other person can be seen through video. Can the board deny him the right to particular through the VC? Being the chairman, does he have the discretionary power?
See, in fact, on the face of it, it seems to be purely hypothetical question. This is, but if at all it is really happening, the board can certainly, ask the chairman to ensure that he has to conduct the meeting, because see that one of the duties of the chairman is to uphold the chairman as well as the company secretary both to uphold the integrity of the meeting. So here, if the chairman himself is what's called as taking the integrity of the meeting for a toss, then maybe the company secretary has to intervene. Savithri, you may add to your views, please.
Absolutely. And this is one where the chairman is responsible for the conduct of the meeting. And this goes to the root of conduct of the meeting, and decorum needs to be maintained. Decorum does not just mean disturbance by making noise. Decorum is maintaining the rules of the meeting. One of the rules of the meeting is to ensure that no other person has access. So I would say that denying him right to participate is an extreme step. I would in fact say that the chairman should very clearly draw his attention. He should stop the proceedings for a brief while, draw the attention of the director, requesting him to ensure that no other person is allowed to enter the room. And if despite that this is not maintained, he will have to then tell him that, we are going to blank out your connection because this is not in accordance with the rules of the law.
In fact, if I am not wrong, in SS1, it is mentioned clearly that it is the responsibility of the chairman and the company secretary to uphold the integrity of the meeting. So here, company secretary has to ensure that the integrity of the meeting is upheld, and he cannot become submissive to the chairman. And if the chairman is doing like this, what can I do? He cannot say that. Company secretary is a legal position, and he has certain inherent rights provided under the act itself. And this particular the power he has been provided under SS1.
Can notice less than 21 days possible if the article provides for the same.
Articles cannot override the Companies Act.
Absolutely. Section 6 is very clear on this. You cannot have anything which is not in accordance with the law.
In case of the deemed limited company, up to what time period shall documents such as transcript, scrutinized report, notice, and annual report will be hosted and kept it in the website of the company.
Yes,
I
I
think
already mentioned
Sudhakar
about
has
it.
already answered this question.
Yeah.
That's all I think in the chat box. I am done with the chat box. There's nothing else is there. If there are any more questions from the participants, we can take. Otherwise, I think we are already well in time, more than time, 1 hour, 15 minutes.
2 hours,
So
15 minutes.
We can close the meeting unless there is something is there.
Just for the larger benefit of all the participants here, I would like to just mention, going forward for the next couple of weeks also, we are going to have the webinars on SS3 and SS4 as well. So please be a part of it and register, and so that we can have such great panelists and discussions.
As
then-
as Kanchan rightly mentioned, SS3 and SS4, especially in case of SS3, in fact, several times people call me and put a lot of questions, the dividend disbursements, especially in case of interim dividend, what are the precautions the board have to take and other things. As far as SS4 is concerned, board's report, it is a legal document. Preparation of a board's report, most of the times company secretaries think that just pick up the last year board's report, do the cut and paste thing. If anyone is doing like that, you will be in trouble, because in board's report is a very comprehensive document. Any kind of mishap takes place, you have to revise the board report, for which elaborate procedure is there. Before Bala sir conclude the meeting, I want to say one or two things. Companies Act, normally what happens is whenever we have to comply with, most of the times we give importance to the Companies Act, not to the Secretarial Standards. SS1 and SS2 are part of the Companies Act. I repeatedly say this thing. So it is the compliances of SS1 and 2 are also equally important. Most of the times when the company secretaries, when I was in Reliance, I used to conduct the interviews. I used to ask a question that what is there in SS1 which is not there in Companies Act? What is there in SS2 which is not there in the Companies Act? Because there are certain things which are there in SS1 and 2 which are not there as in the Companies Act. Our Companies Act might be silent about it. People were not able to answer that. So my advice to all of you is please draw that what are there in the Companies Act which is not there in the SS1 and vice versa, so that you will be able to clear with the compliances. For example, agenda you have to say 7 days before as per SS1, which is not there in the Companies Act. You have to circulate the draft minutes 15 days before, which is not there in SS1. There are about 10 to 15 items are there like that in SS1, and an equal amount of things are there in SS2 also. So as I was repeatedly mentioning, considering the regulatory activism, now it is a high time for us to wake up and to keep ourselves agile to the requirements of the regulators. Otherwise, we as well as our companies will be in trouble. I will rest my case here. Thanks very much for all of you for participating in this webinar. Thanks very much, Savithri, on behalf of Mehta and Mehta, as well as on my personal behalf, for spending your valuable time, and look forward for more interactions with you in the coming webinars also. Bala sir, you may conclude your bit.
Thanks a lot to everybody. In fact, today's session, 100%, it is very, very interactive session. There has been many questions. There has been many clarification. We had a expert of Savithri and as well as Sudhakar, who has actually provided a lot of insight. Even personally, my learning was also there in some of the issues, because since I'm a very old timer, I'm virtually not in that virtual meeting conducting in today's world. So naturally, I also got clarified many things. I am sure the participant would have been greatly benefited to that extent. And especially Kanchan has done a concise job of putting the slides and giving us insight of the SS2 in a capsule form. And she allowed a greater participation, and she herself raised many issues, etc. Based on that, we had a fruitful discussions. Many thankful to all the participants. There are a lot of appreciation has also come here in the chat box, which I'm reading, which I'm not reading it, but many people have expressed. It's a great session. Thanks a lot, Savithri. Thanks a lot, Sudhakar. Thanks a lot to our participants. Thank you very much, Kanchan, for your nice preparation. I think with this we end the session. Thank you.
Thank you, ma'am. Thank you for your time, ma'am. Thank you, sir.
Thank you.
Have a good weekend.
Thank you.
Bye.
Thank you very much.